So good day, sir. My name is Regin Candido from Section D, and today I'm going to answer the following questions for our final examination in CLJ 400. So first is define evidence and explain its scope. Revised Rules on Evidence, Rule 128, Section 1. Evidence is the means sanctioned by these rules of ascertaining in a judicial proceeding the truth of respecting a matter of fact. So the scope of evidence shall be the same in all courts and in all trials and hearings, except as otherwise provided by law or these rules. So second is, what are the three kinds of evidence? So there are three kinds of evidence, namely real evidence, documentary evidence, and testimonial evidence. So when we talk about real evidence, are evidence that are tangible object or sound recording of a conversation that is offered in evidence, while documentary evidence consists of writing or any material containing letters and words. And the third one is testimonial evidence. It is an evidence in a court of law that cannot be supported by physical evidence but is provided by a credible witness under oath. Distinguish corroborative evidence from cumulative evidence. Corroborative evidence is additional evidence of a different kind and character tending to prove the same point. It is a piece of evidence that may be derived from various sources but proves a common point. Meanwhile, cumulative evidence is additional evidence of the same kind and character tending to prove the same point also. That is purely the accumulation of similar evidence that is derived from common sources. Next, the fourth one is, what is prima facie evidence? So prima facie evidence is an evidence which, if unexplained or uncontradicted, is sufficient to sustain a judgment in favor of the issue it supports. Otherwise, if opposing party does not offer an explanation and present contrary evidence, then the prima facie evidence will be enough basis for the court to rule in favor of the party that offers the prima facie evidence. So let's move on to number 4. What is dying declaration? What about statements uttered as part of the res gestae? So according to section 38, dying declaration is a declaration of a dying person made under the consciousness of an impending death, may be received in any case wherein his or her death is the subject of inquiry, as evidence of the cause and surrounding circumstances of such death. Statements uttered as part of the res gestae is a statement made by a person while a startling occurrence is taking place or immediately prior or subsequent thereto, under the stress of excitement and caused by the occurrence with respect to the circumstances thereof, may be given in evidence as part of the res gestae. What is the order of examination of individual witnesses? So define each. The order of examination of individual witnesses are direct examination by the proponent, next is cross-examination by the proponent, redirect examination by the proponent, and recross-examination by the proponent. So when it talks about direct examination, it is the questioning of a witness by the lawyer side party that called such witness in a trial, while a cross-examination is the act of opposing party questioning the witness during a trial. Generally, a witness is initially questioned by the party who called them to the stand on direct examination. Redirect examination by the proponent means to afford the party calling the witness to explain or amplify the testimony given on cross-examination, to explain apparent contradictions or inconsistencies, and to rehabilitate the testimony. Last one is recross examination by the proponent. It is the questioning of a witness who has already provided testimony under oath in response to direct examination as well as cross-examination by the opponent. Question number 7 is, briefly explain what is judicial affidavit. Judicial affidavit is a statement of a witness given under oath, intended to take the place of their testimony in court given during direct examination. So it is written out of court statement taken before a notary public or any person authorized to administer oath. Number 8. An offer of compromise in criminal cases is an implied admission of guilt. What are the two exemptions? So there are two exemptions in implying admission of guilt. So first is, in criminal cases, except those involving quasi-offenses or criminal negligence, or those allowed by law to be compromised, an offer of compromise by the accused may be received in evidence as an implied admission of guilt. So the other one is a plea of guilty later withdrawn, or an unaccepted offer of a plea of guilty to a lesser offense is not admissible in evidence against the accused who made the plea or offer. Number 9. In order for evidence to be admissible, it must be relevant and competent. When evidence relevant? When is evidence competent? So the answer here is, evidence can be competent when evidence is relevant, if it has a relation to the fact in issue as to induce belief in its existence or non-existence. Competence in addition to relevance, admissible evidence must also be competent. So it is under Rule 128, Section 3, that evidence is competent if it is not excluded by the law or these rules. Number 10. What is a leading question? When is it allowed? So, a leading question is a question that suggests a particular answer and contains information the examiner is looking to have confirmed. Leading questions are generally not allowed on direct examination except to develop a witness testimony. Number 11. What is a misleading question? So, a question which suggests to the witness the answer which the examining party desires is a leading question. A misleading question is one which assumes as true a fact not yet testified to by the witness or contrary to that which he has previously stated. Number 12. When is circumstantial evidence sufficient to sustain a conviction? So, circumstantial evidence is sufficient to sustain a conviction is when there is more than one circumstances. So, the fact from which the inferences are derived are proven, and the combination of all the circumstances is such as to produce a conviction between reasonable doubt. Number 13. Distinguish burden of proof from burden of evidence. So, burden of proof is the duty of a party to present evidence on the facts in issue necessary to establish its claim or defense by the amount of evidence required by law, while burden of evidence is the duty of a party to present evidence to establish or rebut a fact in issue to establish a prima facie case. 14. What is the standard of proof necessary in civil cases? In civil cases, the party having the burden of proof must establish his or her case by a preponderance of evidence. Criminal cases, the accused is entitled to an acquittal unless his or her guilt is shown beyond reasonable doubt. 15. Administrative cases. Briefly define each. So, in administrative cases, a fact may be deemed established if it is supported by substantial evidence or that amount of relevant evidence which a reasonable mind might accept as adequate to justify a conclusion. 16. Define what are public documents. So, public documents are the written official acts or records of the sovereign authority, official bodies and tribunals, and public officers, whether of the Philippines or of a foreign country. Second is documents acknowledged before a notary public, except last wills and testaments. Third is documents that are considered public documents under treaties and conventions which are enforced between the Philippines and the country of source. And the third one is public records kept in the Philippines of private documents required by law to be entered therein. 17. How do you prove and present in court private documents? By the means of, number 1, by anyone who saw the document executed or written. Number 2 is by evidence of the genuineness of the signature or handwriting of the maker, or third one is by other evidence showing its due execution and authenticity. 18. The original document rule states that when presenting a document as evidence, only the original is admissible. What are the 4 exemptions? So first is when the original is lost or destroyed or cannot be produced in court without bad faith on the part of the offerer. So that is one exemption. Second is when the original is in the custody or under the control of the party against whom the evidence is offered, and the latter fails to produce it after reasonable notice, or the original cannot be obtained by local judicial processes or procedures. So number 3, when the original consists of numerous accounts or other documents which cannot be examined in court without great loss of time, and the facts sought to be established from them is only the general result of the whole. And the fourth exemption is when the original is a public record in the custody of a public officer or is recorded in a public office, and when the original is not closely related to a controlling issue. Next, we have 19. Who can become a witness? So all persons who can perceive and perceiving can make known their perception to others may be witnesses. Religious or political belief, interest in the outcome of the case, or conviction of a crime, unless otherwise provided by law, shall not be a ground for disqualification. And the last one is, when is an extrajudicial confession sufficient to sustain a conviction? So an extrajudicial confession made by any accused should not be sufficient ground for conviction unless corroborated by evidence of corpus delicti. So that would be all, sir. Thank you.